Welcome to Continuing Professional Development. I will be presenting legal updates. A successful society is one which prides itself on making and enforcing just and equitable laws that are equally applicable to all inhabitants. Such laws protect citizens from arbitrary, unfair, and discriminatory conduct. They provide meaningful growth for all citizens equally in accordance with acceptable norms. And they provide a transparent and universal application of the law in the interests of everybody. We're going to discuss first the difference between criminal and civil law. This causes a great deal of confusion amongst people generally, and particularly amongst those who may incur liability in the course of what they do. Our law is divided into two sections, criminal and civil. And in order to explain, I'm going to use the example of the drunk driver. We'll call him Mr. Johnny Walker. Mr. Johnny Walker has been attending with some friends on a party and has decided to imbibe a great deal of his favorite drink. As a result, he is somewhat befuddled and is not in a position to drive safely. Nevertheless, around midnight, he gets into his car, leaves the Heavenly Bills Hotel in Umhlanga Rocks, and makes his way towards the freeway. Unfortunately, just at this time, his wife gives him a call on his cell phone to find out where he is, and in the process of trying to convince her that he is in fact not drunk at all, but has all his faculties at his disposal, he doesn't notice a red robot, drives straight through it, collides with another vehicle. His vehicle spins around, he loses control, and he climbs the pavement and bumps into Mr. J.C. LaRue, who is making his way home after his friend's Bulls party. Now, these actions can result in criminal and civil sanctions, and we'll look at both. First of all, a crime is one which causes a person, as a result of his actions, to become liable and guilty of an offense. Criminal law deals with crimes where the state is one party and the accused is the other. A person undergoes a trial and is found guilty or not guilty. And if he is convicted, he is sentenced to some form of sanction. It may be imprisonment, it may be a fine, it may be a suspended sentence, it may be some form of specialized incarceration, which our law recommends. He will always have a criminal record. Now, the criminal law consequences of Mr. Johnny Walker's actions are that he will be charged, first of all, with drunken driving. He will have to be tried. A prosecutor will prosecute him and present the evidence. He may be convicted and sentenced to imprisonment or a fine or both, and he will always have a criminal record. Fortunately for him, Mr. J.C. LaRue was not killed due to his highly relaxed state brought on by his favorite drink, but he breaks his leg as a result of the collision. And therefore, there is no criminal consequence to the assault on Mr. J.C. LaRue. It's not an assault in law, it was not done intentionally, and there is no criminal sanction. Had he, however, died, Mr. Johnny Walker may have found himself charged with culpable homicide. Now let's look at the civil sanctions which result from Mr. Johnny Walker's actions. First of all, a civil suit arises as a result of patrimonial loss. Patrimonial loss is monetary loss. The plaintiff sues the defendant, who is the person who perpetrated the event that caused the loss. The action is instituted between two persons. The state is not involved. As a result of a successful claim, a judgment can be issued by the court, and the judgment usually will sound in money, as a result of which the defendant is required to pay certain amounts to the plaintiff, and if he fails to do so, a writ of execution against his property can be issued. No crime is involved and no criminal record will be noted against the defendant in such matters. All right, that's the basics of our civil and criminal law. The basis of civil liability in South African law is either delictual or contractual. And in dealing with this, we're going to look at the concept of negligence. In order to be successful in a claim under delict in our law, a plaintiff must prove, first of all, conduct, which could be an act or an omission, depending on the circumstances. He must prove wrongfulness, which is objective, unreasonable, and unjustified conduct. If the person in any respect acts unreasonably and unjustifiably in his conduct, it renders his conduct wrongful. There must also be an element of fault, which is what we call culpa in Latin, and it translates to blameworthiness. Causation is another requirement, and this is the fact that it must be shown that the act caused the damage and the damage which was occasioned was reasonably foreseeable. And then finally, in order to succeed in a delictual claim, there must be real loss suffered. The other type of civil liability is incurred under our law of contract. So if it's not a delictual claim, it may well be a contractual claim. And on that basis, obviously, you must have first a valid contract. Remember that a contract doesn't have to be a written contract unless there is some legislation which requires it to be in order for it to be valid. So a verbal contract is just as binding in most instances as a written contract. It's just more difficult to prove and therefore not usually a good idea. On top of the valid contract, we must have a breach of such contract, a breach of some term that is contained in the contract, and there must be damages resulting from the breach. Bear in mind that even if these elements are proved, the civil action will not succeed where the defendant is able to raise a defense to the claim, which is valid in law. This brings us to the concept of negligence. Negligence occurs where a person unintentionally commits a wrongful deed. In order to determine whether an act is negligent or not, the reasonable man test is used. The old Latin fathers in Roman law used to call the reasonable man test the test of the bonus parte familias, which translate means the good father. And you would always consider any conduct against what was the expected conduct of the good father, or in our current law, the reasonable man. And the test poses two questions. Would a reasonable man have foreseen that the conduct would cause damage? And if so, would a reasonable man have taken steps to guard against that damage? And a person is negligent if the answer to both questions is in the affirmative, and he continued to act in that manner. It should be noted that the reasonable man test is more onerous if there is a greater duty of care on the person than would usually be expected due to, say, the person's knowledge, his skill, his expertise, or an assumed obligation to the plaintiff. Examples of this may be any of the following. The old case of State versus Blom is well known in our law amongst lawyers in general, and it relates to an event where a person was imprisoned, was arrested by the police, and while he was in custody, he was assaulted seriously by certain policemen. The person who was on duty in the office at the time, who was also a policeman, heard a great deal of commotion going on in the cells, took no notice of it, and failed to act or intervene in protecting the life and limb of Mr. Blom. And as a result, he was found to have been liable for the consequences of what was done to Mr. Blom on the basis that he had a duty to act and he failed to do so. And as a result of his expertise and his assumed obligation to the plaintiff, he was negligent in not going to Mr. Blom's assistance. Other examples might be professional persons such as doctors, nurses, teachers, caregivers, and of course, estate agents. So if you as an estate agent put yourself in a position where you have specialist knowledge, you assume an obligation to your client, and you fail to act in the way that you should in protecting your client, you may well be found to be negligent as a result of what you do if such conduct causes damage to your client. Just to look at one of the decided cases, and the reason we look at decided cases is simply that our law is based on the concept of stare decisis, which means that we follow the decision. So our law is changed, amended, nuanced by our courts on a daily basis. And the decisions of our courts are binding in respect of other courts that follow. In the matter of Rose Lillian Judd versus Nelson Mandela Bay Municipality, for instance, the High Court confirmed that it is commonly recognized that an actionable wrong or a delict comprises 5 elements: the commission or omission of an act, which is unlawful or wrongful, committed either negligently or with intent, that is the fault or culpa element, which results in or causes the harm, and that is the causation element, and the suffering of injury, loss, or damage. These are separate and distinct components of the same delict, each having its own requirements and test. Since South African law does not recognize negligence in the air, the issue of wrongfulness must be determined prior to the question of fault. To expand a little on this, the element of fault is only legally recognized if the act or omission in question is legally wrongful. In the absence of wrongfulness, the issue of fault does not arise. And there's a quotation from the case of the Minister of Safety and Security versus Van Duijvenbode. Negligence, as it is understood in our law, is not inherently unlawful. It is unlawful and thus actionable only if it occurs in circumstances that the law recognizes as making it unlawful. So when negligence manifests itself in a positive act that causes physical harm, it's presumed to have been unlawful, but it's not so in the case of a negligent omission. So a negligent omission is unlawful only if it occurs in circumstances that the law regards as sufficient to give rise to a legal duty to avoid negligently causing harm. Okay? We think of the policeman in the Blom case. He had a legal duty to avoid negligently causing harm. And what was the negligent harm that he caused? He failed to act. He negligently failed to take notice of what was happening and to act in order to prevent the harm. Where the law recognizes the existence of a legal duty, it does not follow that omission will necessarily attract liability. It will attract liability only if the omission was also culpable or blameworthy. In other words, whether a reasonable person in the position of the defendant would not only have foreseen the harm, but would also have acted to avert it. We'll move on then to payment of commission. At common law, an estate agent is entitled to and can demand payment of commission from the mandator or the client, provided, firstly, that the estate agent has received and accepted a valid mandate to render estate agency services on behalf of the client. Secondly, the estate agent has duly performed that mandate and rendered the required services. And thirdly, in the case of immovable property, the estate agent was the effective cause of a sale. Of course, that is the position at common law, and common law can be amended contractually by entering contracts which change those common law provisions. These contracts, however, have to be lawful, not contra bonus mores or against good morals. They must be clear and unambiguous, and they must be agreed to by both parties. Okay? Specifically, in contracts, there may be clauses such as a default clause or a sole mandate clause, and this changes the position at common law. Estate agents will know the instance where you have one of your clients sign a sole mandate, and in terms of that mandate, if you introduce somebody to a property, even if they purchase that property way after the mandate has terminated, you may still be liable for commission in respect of that introduction. And so the requirement at common law of effective cause is no longer required. You may also have an instance where in a sole mandate contract, the contract provides that if another agent sells the property and concludes a successful sale during the period of the sole mandate, that you are also liable for commission to this agent, bearing in mind that you may then be liable for commission to both those agents. One, in terms of the common law requirement of effective cause, if that agent did everything he was supposed to do and did have a mandate from you, and also to the mandated agent in terms of the sole mandate, who is entitled to commission by virtue of the contract alone. Agents should be aware of the provisions of Section 30 and 34A of the Estate Agency Affairs Act, and also the regulations 2, 3, 4, 5, and 8 of the Code of Conduct for estate agents regarding unlawful mandates. Please make sure you have a look at those. It is very important to note that there are certain aspects which may not be contained in sole mandates. There are also aspects which must be contained in sole mandates. And if you fail to include them, you may well be guilty of some form of misconduct which is actionable by the board. Let's move on then to mandates. An estate agent's claim to commission is based on the mandate provided to render estate agency services. Without a mandate, an estate agent is not entitled to payment of commission, even though he makes an effort and can in fact become the effective cause of a sale transaction. Should an estate agent introduce a buyer to a seller without having a mandate from the seller to market the property, the estate agent cannot demand payment of commission from the seller should the parties privately conclude a sale transaction. Performance, of course, is another basis for payment of commission. An estate agent is not entitled to payment of commission unless that estate agent can show that he or she has performed in terms of the mandate. In the case of sales transactions, this means the introduction of a willing and able buyer, a binding sale agreement concluded between the parties. The transaction and its terms must also have been substantially in accordance with the terms of the mandate granted by the principal. It is not sufficient for the agent merely to have been a cause of a sale. Even if the services of the estate agent influenced the conclusion of a binding contract between the seller and the buyer, the agent would not be entitled to commission if other factors, and not his introduction, had actually resulted in the conclusion of the sale. The terms and conditions of the concluded sale must accord with the terms of the mandate granted to the agent. And our courts have, for many years, mulled and considered what are the deciding factors in coming to a conclusion whether an agent was in fact the effective cause of a sale. And the following factors have been distilled out as those taken into account by the courts in deciding this question. First of all, the nature and effect of the agent's efforts. Secondly, the period elapsing between the estate agent's introduction and the eventual conclusion of the sale. Thirdly, the terms and conditions of the sale agreement compared to the terms of the agent's mandate. And whether the efforts of the agent resulted in the conclusion of the sale agreement, notwithstanding the intervention of any other parties. Where a property is listed with a number of competing agents, there is no rule entitling the agent first introducing the buyer to the property to receive commission. The decisive factor is which agent was the effective cause or causa causans of the sale being concluded. Perhaps the offer to purchase obtained by the introducing agent was rejected and a second agent agreed to a reduced commission, which enabled the transaction to be concluded. Perhaps the second estate agent assisted the buyer to obtain mortgaged finance on better terms, which allowed him to increase the purchase price, and that price was acceptable to the seller. Intervening cause extinguishes the previous agent's right to commission based on being an effective cause. And the question then immediately arises, can more than one estate agent be the effective cause of a sale? Where it is impossible to distinguish between the efforts of the different agents in determining who was the effective cause of the sale, the seller may be liable to pay commission to both estate agents. This is one of the risks of granting multiple open marketing mandates. Estate agents should be aware of the provisions of Regulations 2.2 and 8.3 of the Code of Conduct. This legislation imposes duties on estate agents to warn their clients of the possibility of a multiple payment of commission. It also prohibits agents from showing properties to clients when they know that clients have already been introduced to that property by another agent, and a multiple commission scenario may result. We're going to look at the case of Wakefield's Real Estate versus Attree, 2011 case, and the facts of the case are as follows. You'll find them quite convoluted, but not that unusual in the estate agency scenario. In 2001, the Attrees bought Monteith Place through Wakefield's, represented by one Craig. In 2004, they acquired land on which to build another home. Upon hearing of this, a number of agents, including Craig, offered to market Monteith Place for sale. The Attrees were unsure as to whether they wished to sell, but they did not discourage agents from bringing potential buyers to view the property. Craig listed Monteith Place for Wakefield's and advertised it at 3.775 million, although Mr. Attree wanted 3.995 million for the property. During 2005, Mrs. Walker, a Wakefield's estate agent, took prospective purchasers to view Monteith Place. And while she didn't meet either of the Attrees on these visits, she was let in by a domestic worker and always left a card to show that she'd been there. A certain Howard and her husband attended a show day in January 2005 where she met Walker. While she was not interested in the property on show, Walker did make a note of houses to show Howard, including Monteith Place, which Howard loved, but the price was beyond her reach. Despite this, Howard again visited Monteith Place with her husband and spent some time there. When Walker contacted Howard about this after the second visit, she was told that Howard and her husband had decided not to buy a new house. Walker stopped phoning Howard or showing her houses. Shortly afterwards, Howard encountered Mrs. De Marini, an agent employed by Pam Golding Properties, at a shopping centre. Howard, learning that De Marini was an estate agent, told her that she had seen Monteith Place and had really liked it, but it was far too expensive. In early April 2005, the Attrees were advised by Mrs. Hamilton of Remax that they should lower their asking price for Monteith Place to 3.495, and they agreed to do so. They then gave Remax a sole mandate to find a purchaser, arranging for Monteith Place to be put on show on Sunday, the 10th of April. The Remax sole mandate was effective from the 7th of April, but the Attrees mistakenly thought that it commenced only on the following Monday. Remax advertised the house for sale on Friday the 8th at 3.495 million. Despite having given a sole mandate to Remax, Attree contacted two other agents, one of whom was De Marini, on the 8th of April. He informed them that he had lowered the selling price. De Marini then recalled that Howard had liked the property, and on Saturday the 9th of April telephoned her to advise her that the price had been reduced. Howard agreed to revisit Monteith Place with her husband. De Marini prepared an offer of purchase for 3.4 million after agreeing to reduce the commission on the transaction. The Attrees accepted the offer, which indicated that the commission of 150,000 Rand on the transaction would be shared by Remax, which held the sole mandate, and Pam Golding, which claimed to be the effective cause of the sale. The Supreme Court of Appeal agreed that it is notoriously difficult when there are competing agents to determine who the effective cause of the sale was, noting that more than one agent might be entitled to commission. The court referred to the case of Webranchek, which is a well-known case in our law, where it was found that situations are conceivable in which it's impossible to distinguish between the efforts of one agent and another in terms of causality and degrees of causation. In such a situation, it may well be that a principal may owe commission to both agents, and that he has only himself to blame for his predicament, and he needs to protect himself against that risk. A judge who has to try the issue must decide the matter by applying the common sense standards. It stands to reason, therefore, that the cumulative importance of a number of causes attributable to one agent may be such that, although each in itself might have been described as a causa sine qua non, the sum of efforts of that agent may be said to have been the effective cause of the sale. So what the judge is saying there simply is that each little attempt or little bit of assistance by the agent on its own might not have been the effective cause, but when you put them all together, they become the effective cause of the sale. Supreme Court of Appeal referred with approval to the case of AIDA Real Estate versus Lipschitz, where an agent had introduced a purchaser who ultimately negotiated directly with the seller in concluding a sale. The agent was nonetheless found to be the effective cause of the sale and entitled to commission. The judge in that matter affirmed that protracted negotiations concerning finances often ensued before transactions were concluded. In that case, the purchaser had concluded the deal, but it was the agent's wisdom and business acumen that had brought the eager seller and purchaser together, who were able to overcome the financial obstacles. The judge found that in such a case, the agent is entitled to remuneration as a commission agent is paid by results and not by good intentions or even hard work. In the present case, that's the Wakefield's case that we're dealing with, the Supreme Court of Appeal concluded that without Walker's introduction, Howard would not have known of Monteith Place. It was Walker's wisdom and business acumen that had made her take Howard to Monteith Place. Walker had given up trying to negotiate a sale with Howard only when told that Howard had stopped looking for a house to buy. If Howard had herself approached the Attrees and persuaded them to sell Monteith Place to her at a lower price, then Wakefield's would have been entitled to commission. If the Attrees had approached Howard directly and offered to sell to her at a lower price, Wakefield's would also have been entitled to commission, since Walker was the effective cause of the sale. De Marini had only fortuitously learnt that Howard was interested in Monteith Place. She did nothing about it until contacted by Mr. Attree to reduce the selling price. De Marini had then telephoned Howard, arranged for the Howards to see Monteith Place, drawn up the offer to purchase, persuaded the Attrees to further lower their price, and accepted a reduced commission. While De Marini was undoubtedly instrumental in concluding the sale, she was reluctant to admit that Walker's introduction and the work of the Remax agent who had persuaded the Attrees to reduce the asking price had an effect on the sale of Monteith Place. Had Walker not made the initial introduction, Monteith Place would not have been sold to Howard through Pam Golding. But for that introduction, De Marini would not have known that the Howards were interested in the property and would not have found a willing and able purchaser before the scheduled Remax. The SCA found, therefore, that De Marini had reaped where she had not sown, and that despite De Marini's later intervention, Walker's introduction was the effective cause of the sale. That the Attrees were, in the event, liable to pay more than one estate agent, remember the sole mandate, was a problem of their own making, and they had only themselves to blame for their predicament. And that wraps up mandates. We'll move on then to Section 118.3 of the Local Government Municipal Systems Act 32 of 2000. All right, this section of the Municipal Systems Act is very important. You will remember previously that the law was somewhat different. It has been changed in the interim, and this is to explain to you how. Section 118 of the Act in question prescribes that a register of deeds may not register the transfer of a property except on production of a certificate issued by the municipality in relation to the fact that services, fees, charges, etc., which are attached to the property have in fact been paid. An amount due for municipal services, etc., levies and duties is a charge upon the property in terms of this legislation. And that led to some decisions made previously which have now been overturned by our courts. And we'll look at that briefly. On the 29th of August 2017, the Constitutional Court, after having considered various factors, decided that Section 118.3 must be interpreted to the effect that the charge against an immovable property does not survive the transfer of the property into the name of a purchaser of that property. So just to paraphrase that, what we're saying is that where certain amounts are owed, the property is transferred with a certificate confirming that the previous 2 years' amounts owing have been paid, but there is a historical debt attached to that property, that the new owner is then not liable for that debt, which previously he was. The court held that a mere statutory provision that a claim for a specified debt constitutes a charge on the immovable property does not make that charge transmissible to a successor in title of that property. A public formalization of the charge is required and notice to that owner before such an obligation can be created. And since Section 118 does not require any public formalization, that effect does not follow. Section 25 of the Constitution prohibits the arbitrary deprivation of property, which would happen if a new owner was subject to the execution against his property for a previous debt that had nothing to do with him. So to avoid unjustified arbitrariness in contravention of Section 25(1) of the Constitution, Section 1183 must be interpreted to the effect that the charge it imposes does not survive transfer to a new owner of that particular property. Right, I think that's fairly clear, and please take note of the change in our legislation and our court decisions in that regard. We move on then to the limitation of real rights in immovable property and refer to the recent case of Gees versus Provincial Minister of Cultural Affairs and Sport, Western Cape and others, where it was held that onerous conditions imposed by a heritage authority for the redevelopment of an immovable property was not a deprivation of the constitutional property rights of the owner of that property. And the facts briefly are as follows. Gees wanted to redevelop a property that he owned. He wanted to demolish the building on it, which was more than 60 years old. In terms of Section 34(1) of the National Heritage Resources Act, he couldn't do that without the authority of the relevant Provincial Heritage Resource Authority. Gees therefore requested a demolition permit. The Gees and the Western Cape Heritage Authority agreed that while the building was not worthy of protection, the surrounding area was. In fact, it was conservation worthy and a demolition permit was granted subject to some very onerous conditions. Gees was unhappy with those conditions, went to court to have them set aside. And when the High Court refused the application, Gees appealed that decision to the Supreme Court of Appeal. And he argued that the National Heritage Resources Act did not authorize officials to impose conditions on the development of a property that had no formal heritage status when granting a demolition permit. The Supreme Court of Appeal held that since the conditions imposed were clearly designed to enable Heritage Western Cape to fulfill its duties under the Act, they were lawfully imposed. The appeal was dismissed, and the court found in the circumstances that there was no arbitrary deprivation of Gees' right of ownership, and the imposition of the conditions by Heritage Western Cape was reasonable and equitable, having regard to Gees' inherent responsibility towards the community in the exercise of his entitlements as the owner of the property in question. So we see that increased emphasis is being placed on the characteristic of ownership in our country, which requires that entitlements attaching to ownership of property must be exercised in accordance with social function of law and in the interests of the community. And it underscores the fact that rights attaching to property are in fact limited real rights. We move on then to incidents of racist or discriminatory behaviour. You may be aware of the matter of Vicky Momberg, a former estate agent who was recently found guilty of 4 counts of crime and injuria as a result of racist outbursts directed at telephone operators and a black police officer. The court found the remarks to have been racially made and intentionally directed at black people. The EAB and its stakeholders are, of course, appalled at the many reported incidents of racist behaviour perpetrated by persons acting as estate agents or purporting to do so. And it has, as a direct consequence, instituted appropriate strategies and programs which are aimed at eliminating the scourge of racism within the estate agency sector. The objectives of the EAAB's anti-racism and anti-discrimination strategy are to, firstly, create an increased awareness of racism and the ways in which it insidiously affects individuals, the South African community, and the estate agency sector in particular. Also, to identify, promote, and build on good practice initiatives to eliminate racism and discrimination generally, as well as, more specifically, within the estate agency sector itself. The objectives of the anti-racism and anti-discrimination strategy are to empower affected communities and individuals to obtain relief and redress in instances of racism or discrimination, if it is perpetuated by estate agents or persons holding themselves out to be estate agents. Also to ensure the eradication of any perceived barriers to equality as a result of facets of racism that may still be prevalent in the estate agency sector. Estate agents are currently regulated by the Estate Agency Affairs Act, which was brought into being in 1976. As a result, we know that it does not serve its purpose in regulating estate agents and property practitioners effectively. As a result, a property practitioners bill is in the pipeline and we are hopeful will be promulgated shortly. The property market contributes some 8% to the South African gross domestic product. The total value of the South African property market is estimated to be around 7.9 trillion rand. A transformed property sector is an economic imperative. Consumer education and empowerment is equally important, and the Property Practitioners Bill, in taking cognizance of all of these aspects, also seeks to introduce new role players as property practitioners. For example, bond originators, bridging financiers, valuators, and home assessors. The structure of the bill is set out briefly in the slides, and you will see Chapter 1, as usual, relates to definitions. Chapter 2, the establishment of the Board of Authority, which will take the place of the Estate Agency Affairs Board. Chapter 3 is the appointment of officials, and Chapter 4, the establishment and appointment of the Property Practitioners Ombud, which is a new device being brought in terms of that bill. Chapter 5 relates to the management of the funds of the authority, and Chapter 6 to the Property Practitioners Fidelity Fund, which is akin to the current Fidelity Fund. Its control and management, grants it may make, indemnity insurance, fees payable in respect of the fund, etc. Chapter 7 continues and relates to the application for issue of Fidelity Fund certificates, various mandatory time periods, the withdrawal and lapse of Fidelity Fund certificates, and disqualification of agents. Chapter 8 relates to Property Practitioners Code of Conduct, sanctionable conduct, undesirable practices, etc., very similar to our current Section 30. Chapter 9 relates to mandatory disclosures, consumer education and information, and Chapter 10 relates to the imperative of transformation, legal proceedings against the authority, and transitional provisions. If we look briefly at the definitions, the bill expands the definition of property practitioner to include those other role players mentioned earlier, such as bond originators, bridging finance companies, etc. It also creates a new class of property practitioners to be known as property assessors or inspectors. Intern agents will also be known as candidate estate agents, and the bill applies to the marketing, promotion, managing, sale, letting, financing, and purchase of immovable property, and to any rights, obligations, interests, powers, and duties associated with or relevant to such property. So it's a very wide definition. There are specific provisions which enable various procedures to be followed, some of which are not to be found in our current Act. There are provisions for an exemption from certain provisions of the Act which can be granted by the Minister. The composition of the board is also reduced. The appointment of inspectors and powers of inspection is reinstituted. Compliance notices and fines are brought into existence. The property practitioner's ombud, appointed by the Minister for 5 years, is also instituted with powers of mediation and adjudication, and, interestingly enough, includes inter-property practitioner disputes, which currently do not fall within the purview of the Estate Agency Affairs Board. Also, costs of audit, investigation, and inspection are recoverable from property practitioners in terms of these provisions. Grants are payable out of the Fidelity Fund for transformation and consumer education, and claims for misappropriation of trust monies payable only for actions of licensed property practitioners is now instituted. So this means any claimants who make use of illegal, unlicensed estate agents will have no claim against the Fidelity Fund for any loss. Some new disqualifications are brought into existence. A non-citizen or an unlawful resident is now disqualified from being an estate agent. A person found guilty of contravening the Act in the preceding 5-year period also, and persons who are not able to produce a valid tax clearance certificate are also disqualified. There are some important aspects relating to remuneration or commission. First of all, no commission may be paid to a property practitioner who has not been issued with a valid Fidelity Fund certificate. That is the same as it is currently. However, the following provisions strengthen that provision. Any commission paid to a property practitioner who has not been issued with a valid Fidelity Fund certificate must be repaid on demand. Currently, our law does not require that. And thirdly, no conveyancer may pay commission to a property practitioner who has not been issued with a valid Fidelity Fund certificate. That will assist us in regulating the industry. And non-compliance constitutes an offence. The current status of the bill was published for public comment, information sessions were held, revision of the bill taking comments received into consideration occurred. The bill is now to be retabled in the Cabinet for introduction to Parliament, and once it has been passed by both houses, it will be signed into law by the President. That brings me to the conclusion of the presentation. Please remember to answer the 10 multiple choice questions to obtain your 5 verifiable CPD points for this session. Thank you.